Morning. Please be seated. This is the time set for oral argument in the case of Desert Palm Surgical Group versus Sherry Petta, our civil number 13-0376. Each side will have 20 minutes within which to present their arguments here this morning. Appellant may preserve some portion of that for rebuttal. It's up to you to keep track of your time in that regard, however. We have read the briefs. We've been through the record. We're familiar with the underlying facts and the issues. So please take that into account as you make your arguments here this morning. We are recording the proceedings by audio. So when you approach the podium, counsel, please identify yourself and your client for us. We're also recording it by video, and so in a matter of a few weeks, if you really want to see what you look like, you can go on YouTube, where the argument videos are posted, and you can see how that goes. With that, counsel, you may proceed.
Good morning. May it please the court. I am Ryan Lorenz with co-counsel Sean Carroll on behalf of the appellant Sherry Petta. Ms. Petta is seated in the courtroom just behind the bar and is present with us today. Today we seek relief and refuge under the First Amendment of the Constitution. The First Amendment is the basis and the root of all of the law that assists a party to make statements within certain limitations as to whatever they want. It's one of our most basic and fundamental rights.
Well, the First Amendment certainly protects an individual's right to speak, but if the speech is slanderous or defamatory, there may be a price to pay for that. Would you agree?
I would agree. Those limitations of free speech are bounded using a popular metaphor. A person's right to swing their arm ends at the end of another person's nose. In the context of defamation and false light invasion of privacy, the right to free speech cannot be exercised in offense to a person's property right, which is their vested right in their own reputation. As to the claim for false light invasion of privacy, it's the right to continue to have private facts not be brought to the public's attention in an unreasonable, offensive way.
Was the jury improperly instructed as to that defense, constitutional defense?
Your Honor, this case was tried on jury instructions which were still in their infancy. They were not formally published in the revised Arizona jury instructions. They were still a draft version. As far as the work of the committee on the State Bar, as of December 2011, these instructions were not finalized by the State Bar. Setting aside,
when they were finalized, were they different?
I don't believe they were in any significant part.
I'm not sure I'm following your point then.
Well, my point is that these instructions are new, haven't been completely vetted, and haven't been reviewed extensively by any appellate courts to date. They originate from our case law as well as United States Supreme Court case law.
That's not the issue the issues you're raising on appeal. You're contending that the jury was improperly instructed.
That's correct. The instructions were given, they were agreed upon, and the jury is our contention didn't follow those instructions by lending inappropriate weight to evidence and reaching a verdict which was the product of passion or prejudice.
Wasn't the trial court in the best position to evaluate the effect on the jury of that evidence?
Of course, and that's why this court lends great deference to the trial judge's determinations. The trial judge has the better perspective. This particular case, though, stands out in contrast to others because the facts here and the evidence presented have gaping holes. The largest holes in the plaintiff's case in the trial court stem from the damages and causation evidence. The damages evidence given was primarily that Dr. Albert Carlotti suffered emotional distress. He claimed physical problems stemming from that. In addition, there was...
What's the problem with that evidence?
The problem with that evidence is that it didn't link back to the discrete statements made by Ms. Petta.
Did Dr. Albert Carlotti say that her statements caused him this emotional distress?
No, in fact, the testimony suggested that it was a broader issue. It was all of these things happening at the same time. The Carlotti's practice had experienced financial setbacks, had experienced a loss in revenue of, according to Michelle Carlotti, a 70% drop in revenue just for Dr. Albert Carlotti.
Well, Mr. Lawrence, I have to say I actually read their testimony pretty carefully on these points, and rightly or wrongly, both physicians clearly attributed both the drop in business income, or collections, I think was the word that was used, and the physical manifestations Dr. Albert Carlotti complained of to your clients' web posts and filing of board complaints and encouraging participating with others in filing board complaints against them. So I'm not sure I'm following how your argument is.
As far as economic damages, we can't ignore the fact that in 2008, 2009, 2010, this country was undergoing a serious recession. That means discretionary spending on things like elective or cosmetic surgery had to dwindle. Judge Sprain dealt with that issue at the summary judgment level and talked about that issue. That is something that the plaintiffs bore the burden of proving was not the cause, in fact, of their loss in business revenue. And that could have a I'm sorry, Your Honor.
I hesitate to interrupt you again, but did the plaintiffs, the doctors, bear the burden of disproving that other things were not the cause of their downturn in their income, or did they simply bear the burden of saying to the jury, look, this problem was caused by Ms. Pett, and then the jury decides?
That evidence in isolation wouldn't be adequate to carry the plaintiff's burden of proof. Just saying we think that was the cause of it. Well, again, there were medical board complaints filed by people other than Ms. Petta, and those have a qualified privilege attached to them as well. So the fact that they were made and had an impact is no occasion to impose civil liability, because those statements cannot be tied to or cannot be the cause of any injury because they're legally recognized as protected speech. Secondly,
the jury was instructed on the privilege, the qualified privilege, and the fact that the privilege can be lost through abuse. With a general verdict like this, it's pretty difficult to tell what the jury went with. Was it a verdict based on defamation? Was it a verdict based on false light? Was it a combination of both? How did they evaluate the nature of the privilege? Did they find it had been abused? In the closing arguments, there certainly was not. There was no argument to the jury about damages from either side, which I thought was interesting. But I'm concerned about what you think it is we can do here.
As far as how the jury reached its verdict, of course, we never know what happens back in the jury room. We do know from the verdict form that this was a general damages verdict. However, in the two cases that the appellees cite, the Mercat case and the Mullen case, both of those cases involved a higher modicum of evidence. In Mercat, an expert witness came forward and testified that Mr. Mercat lost in an employment dispute over $2 million. So the jury's verdict of $1.75 million in his favor in that case had some basis in the evidence. In the Mullen case, it was a legal malpractice case in which the case within the case that had to be proven was undue influence. The court found evidence in the record of 7 out of 8 factors that supported an undue influence determination. So the jury's verdict was supported by much more evidence, expert witness testimony, than was presented here.
But what can we do? What does the law empower us to do on appeal?
The relief that we're asking for is to have this case sent back with either instructions to enter judgment as a matter of law in favor of Ms. Petta or for retrial. Probably the largest problem is the tenuous evidence of causation. This is an issue that was just barely discussed in the appellee's answering brief. The appellees concede that they have the burden to prove that, but they can't link it back to discrete speech by Ms. Petta. Also, the point should not be lost that Ms. Petta's website postings were only there for a short period of time. In addition, Judge Brain held in a pretrial conference that the plaintiffs would not be allowed to bring forth evidence in the form of proof of a supplemental complaint they proposed to file that post-dated the filing of their amended complaint in January 2010. So that was the cutoff date for presentation of evidence of the underlying liability.
At the trial court level, in the post-trial motions, you also asked the trial court to order a remediator. And that's one of the issues here on appeal. You contend the court abused its discretion in denying the motion for new trial or in the alternative denying remediator. Does this appellate court, in your view, have authority to order a remediator?
Your Honor, that's probably the second largest gap in what happened below. It's just untenable to reach a verdict of this magnitude. This was the second largest verdict in the state of Arizona in 2011. It was the 30th largest verdict in Arizona in the last 10 years. It is approximately quadruple the size of the next largest defamation case verdict. So these figures alone suggest that this case in isolation sits in isolation. These damages can't be linked back to any evidence or even presumed damages because the losses that were discussed, even if they could be proven to have been caused by Ms. Petta, were that Dr. Albert Carlotti lost about $1 million in revenue per year. If we multiply that times the number of months that the plaintiffs claim injury, we're talking about a year and 9 months, which only works out to be $1.75 million. The emotional distress component of the damages, if that was what the jury found to be the rest, would be well over $9 million. So we're talking about dollar figures and a lot of zeros at the end that just don't comport with the trial evidence, which is particularly important to recognize that Ms. Petta maintained that she was speaking the truth and she was exercising her First Amendment rights.
Well, I understand that's your view of the evidence, and well, I guess my question was, having asked for a remediator at the trial court level, and the court declining to do that, and now you're up here in front of this court. Judge Johnson says, well, what do you think we can do? And my question was, do you think the appellate court has authority to order a remitted, if this verdict shocked our conscience, and we thought it was excessive? And obviously, I'll be interested in what Mr. Kelly has to say as well.
Well, and I'm not suggesting this court substitute its judgment for the trial judge. That's not what we're asking this court to do. We're asking the court to examine the entire record and evaluate whether Judge Brain abused his discretion in upholding a staggering jury verdict, which couldn't be linked back to trial evidence. In his minute entry ruling on the post-trial motions, Judge Brain discussed a relentless attack committed by Ms. Petta. But the trial evidence was not that strong. The trial evidence shows web postings that lasted a matter of weeks, not months, not years. The web postings also, the other part of the plaintiff's claim is that the medical board complaints were part of this relentless attack. Yet there's nothing in the record, not one single exhibit of a written complaint, a case number, an administrative agency determination. The only administrative determination that is of record in the trial exhibits was a letter of reprimand to Michelle Carlotti from April 2009, and it's trial exhibit 124, in which the board chastised Dr. Carlotti for maintaining a website that suggested she was board certified. So
the testimony, as I understood it, was that Ms. Petta filed multiple complaints with the medical board. Other individuals that she assisted filed complaints. And if I understood the testimony of Ms. Wynn and the Carlottis, each of those complaints was dismissed, and Dr. Carlotti felt, in his words, vindicated at some point in time, and that seemed to put the parameters on the damage claim, general damages and otherwise.
It's certainly too late for me to object to the presentation of that evidence under the original writing rule of evidence. However, the court still does have the opportunity to review the record as a whole and evaluate that the best evidence of those complaints was not presented to this jury. What Ms. Petta said in those complaints, what she said in an open meeting where people are invited to come speak and discuss issues that affect the medical board or doctors who are regulated by it, none of that's quoted. These aren't recorded. Those statements were never actually presented to the jury. It was simply what other people said, what Ms. Petta said. And so looking at that in a public agency presentation or a public agency complaint and treating that as cause for civil liability goes way too far. If there are no other immediate questions, I'd like to reserve the balance of my time for rebuttal.
All right, thank you.
Morning, Your Honors. May it please the court, counsel. My name is Matthew Kelly, and I represent Desert Palm Surgical Group, along with Doctors Albert and Michelle Carlotti, who are present in the courtroom today. I've had a number of cases before this court, and I think this is the first time that I've ever been trial counsel and appellate counsel. So I kind of have a unique perspective as to how this case has progressed over time. What I can say is that this case was never a First Amendment case. That was not a defense that was presented to the jury. Wasn't part of the jury instructions. What I can also tell you is that the jury instructions that were given with respect to defamation, they were in the preliminary stages, but they were ultimately the preliminary RAJIs. I don't know what the status of those jury instructions are at this point, but Judge Brain did present to Mr. Woodfork and I these jury instructions, and I fought vigorously against them because I didn't think that they accurately set forth the standards. But ultimately what happened was that the burdens of evidence were heightened from my perspective, for my clients. And the jury was instructed to find these higher burdens, and they did with this general verdict. With respect to the damages, the issue of passion or prejudice was presented to Judge Brain. And Judge Brain went back and said he looked at the record, reviewed the evidence, and determined that this wasn't an issue of passion or prejudice. This was the relentless attacks by Ms. Petta. And we're not talking about just the internet stuff. This dealt with all of the attacks that Ms. Petta launched with various administrative agencies.
Let me ask you this question. I apologize for interrupting. Do you think, as a matter of law, a court has to find that the verdict was the result of passion or prejudice before it can do something about it? In other words, if the court believes that the verdict was excessive, but not necessarily because of some prejudice that the jurors may have felt for some reason, but instead simply believes they got it wrong, that the damages are not supported by the evidence, and therefore it's excessive, is that grounds for granting a new trial or a remedial?
I think it is. I think what this court needs to do is give deference to the trial court, who was essentially the ninth juror in this case, who viewed the evidence, who saw the witnesses, could gauge credibility issues. Passion and prejudice is not the only basis for granting a new trial. Quite frankly, if the evidence did not support the damages in this case, Judge Brain could have said just that.
Would you walk me through the evidence concerning any lost profits that your clients offered?
I believe Dr. Michelle testified at length, both in the plaintiff's case in chief and in rebuttal, concerning the disparity and the drop in profits.
Did she use the word profits?
Might have been revenues.
Testifying about net profits, or was she testifying about collections?
I don't know off the top of my head. I don't recall.
And over what period of time was she attributing the loss of profits?
My recollection is probably 3 or 4 years. And I believe her testimony was from the time that Ms. Petta initiated the first medical board complaint in March of 2008 through vindication by the medical board, which I think was 3 years.
What does the evidence show about the practice's net income in 2007?
I'm not sure that there was in 2007.
In other words, at any
Or-
point before this began?
Well, I believe Dr. Michelle's testimony was that there was a 70% drop. I think there was an overall percentage, somewhere in the 30% drop in revenue from previous years. I don't know that there was specific evidence relating to pre-first medical board complaint in March of 2008, other than in the general.
So what basis do the jury have to attribute any loss of net profits to the conduct of the defendant?
Well, the basis was the testimony of Dr. Michelle, who said that, for example, Dr. Albert's revenues or collections, I quite honestly...
You understand my point, though?
I do.
You
I
understand
understand
what I'm
it.
getting to? Because the damage would be, the alleged damage has to be nothing in economic perspective, has to be net, not revenue, not gross. And so I'm wondering what evidence, if any, the jury had of loss in net profits
I don't know that...
attributable to the defendant.
I don't know that... I don't recall that the evidence was stated in terms of net. I believe it was in terms of collection. And I think it was stated more in the general, in the sense that year over year there was X percent drop in collections. So I think from a general evidentiary perspective, the jury did have enough to say, you know, this is the money coming in the door, but it's dropped precipitously since Ms. Petta started her campaign against my clients.
Does it matter if the expenses also dropped?
I would imagine it would, but
Was there evidence of that?
there was not. And there was no objection to that by Ms. Petta, and Ms. Petta did not take my clients to task on that. But I think aside from the special damages, the economic damages, there is a significant general damage aspect to this case that we'll never know why the jury decided to award $11 million in damages. It could be a combination of both. They may not have awarded any economic damages. For all we know, we just can't. We can't.
What would be the elements of $11 million damage verdict if it didn't include any economic loss? Reputation, mental distress?
Absolutely.
$11 million?
Maybe. I don't know. I'm not the jury. I don't get to make that decision, and that's why we have juries. That's why we empower our system of law to allow the juries to make that determination. And the case law is pretty clear. That's peculiarly within the province of the jury, particularly in a defamation type case or a tort case like this.
Except that a judge retains some ability to take action, either in the form of considering a motion for new trial or considering a remediator or additor, as the case may be.
Absolutely.
And so the question I asked Mr. Lorenz, I'm interested in your thoughts as well about this court's ability in the abstract to order an additor or a remediator.
I don't think this court has that power. I think this court has the power to send it back to the trial court for a new determination if it determines that the trial court abused its discretion in not granting a remediator in this particular case. Although I will say that I don't think the opening brief adequately even addressed that issue. All the opening briefs said was we made this motion, judge considered the evidence, and that was it. There was no argument concerning the trial court's abuse of discretion. So setting that aside, I think this court's, to the extent this court thinks that the trial court abused its discretion, notwithstanding the fact that it went back and it reviewed the evidence and made a specific finding that this was not a matter of passion or prejudice, that it was not excessive, and although on the high side, admittedly, the evidence would sustain the finding of $11 million in actual damages in this case. And let's not forget that there was a jury instruction that I fought very hard against that said if you don't find actual damages, you should award nominal damages in the amount of $1 or $100. So, I mean, it's clear that the jury did not determine that the damages here were nominal, clearly. But I think that to the extent, if this court believes that Judge Brain abused his discretion in refusing a remediator on the actual damages, I think the remedy is to send it back to the trial court for a new determination. I don't think that this court has the power to order the damages to be cut in half or any particular number. I think that our Constitution and the statutes that govern this court say that this court can order it back to the trial court, and that's what I think. So,
from a legal perspective, I'm just wondering about the logical differences between a remediator with an option for a new trial. In other words, granting a remediator that that the plaintiff either accepts, or if the plaintiff doesn't accept then there will be a new trial on the one hand and a new trial on the other. It seems to me that viewed in one perspective, a new trial is a subset, the latter is a subset of the former. I'm wondering if a court of appeals has the power to grant a new trial, why it doesn't have the power to do so in the alternative.
Well, certainly the Court of Appeals does have the opportunity and the power to remand it for a new trial. I don't know that this court, sitting with a cold record, has the opportunity or the wherewithal to be able to say Judge Brain abused his discretion in refusing to remit the verdict to X dollars. I think one of two things can happen if this court is convinced that Judge Brain got it wrong. It can send it back for a redetermination as to whether the verdict should be remitted, or send it back for a new trial.
All right, we interrupted your arguments.
I think it's important. The Kramer case, which we cited in our brief, gives the greatest possible discretion to the trial court in terms of remitter. In terms of the medical board complaints, Mr. Lorenz talked about the best evidence rule, the original document rule. The fact is, Ms. Petta admitted at trial that she filed these complaints. So I don't know that we weren't trying to prove the content of the document. We were simply presenting evidence that these occurrences happened, that these complaints were made. And ultimately, Lisa Wynn testified to these complaints. She testified that Ms. Petta made certain statements in front of the medical board. Ms. Petta admitted to her online postings. And so it really isn't a best evidence problem. It is simply the evidence was admitted by Ms. Petta. So I don't know that that's just really not an issue. In terms of the economy, I know that the briefs were rife with economic arguments. That was just not evidence that was presented at trial. And to the extent Ms. Petta wanted to say, hey, the damages that Doctors Albert and Michelle were testifying to were due to something other than her statements, that was incumbent upon her. They didn't have the burden of essentially disproving what she was claiming as her defense. She had the burden of proving.
Did either side attempt to bring forward an expert witness to talk about lost income, business valuation or business income, CPAs or other kinds of experts?
No, Your Honor. Our position was they're business owners and they can testify to their personal knowledge as to what their revenues were and what they ultimately became and from their perspective as a result of what Ms. Petta had published in a number of different forums. But Ms. Petta did have my client's tax returns for 5 years. And although they were produced under a protective order, Ms. Petta never produced, never questioned, never offered those tax returns into evidence. So she did so at her own peril, quite frankly.
May I ask a question about or I'd like to ask a question about the grant of your motion to dismiss the counterclaim.
Yes.
As I understand Ms. Petta's argument, it's that it's not that she didn't consent to a surgery, but that the surgery that she consented to was did not include an outcome of a turned up nose. She consented to the removal of some scar tissue and told the doctor, I don't want a turned up nose, and it turned out to be a turned up nose.
Sure.
Why doesn't that fall within the rule that this is an unconsented to battery by a physician?
Well, first of all, Your Honor, I'd like to address that issue because that's no longer Ms. Petta's claim. That belongs to her bankruptcy trustee, and
Okay.
that was not abandoned by the trustee. I didn't have an opportunity. It was raised in the reply brief. It's not her claim. So
Well, why doesn't the reply brief dispose of that argument from your perspective?
because the trustee has not abandoned that claim. It still belongs to the trustee. But setting that aside, I'll get to the merits of your question. And the case law says if you're consenting to a particular procedure or a substantially similar procedure and you don't like the result, the cause of action is one sounding in negligence. And this was not a negligence claim. This was a battery claim. And the evidence presented to Judge Brain showed that she had consented to a revision rhinoplasty, which included going through the tip of the nose. I mean, I'm not a doctor, but you know, that's what the documents themselves said. And I think, honestly, I think that the joint pretrial statement that was submitted disposes of the issue, because the parties stipulated that she was unhappy with the result of the surgery, not the surgery herself. And Ms. Petta testified in her deposition that she was under sedation. She had no idea who did what and when. And Dr. Albert testified, and I believe gave affidavits saying, I didn't intentionally shorten or curve up her nose. To the extent there was a bad outcome, doctors can't predict how somebody's going to respond, how somebody's going to heal. But it certainly wasn't, I mean, the evidence was that Dr. Albert did not do something against Ms. Petta's wishes.
But her testimony was, I told him explicitly he didn't have authority to do this. He was proposing an extension of this procedure to shorten her nose and to change the shape. And she said, you do not have permission to do that. And if he went ahead and did that, how is that different than the Duncan case? Which our Supreme Court has said, under those circumstances, it's not an outcome, negligence-driven analysis. It is a consent issue.
I absolutely agree. But Ms. Petta produced absolutely no evidence to show that Dr. Albert did what she claimed he did, which was go against her direct wishes to shorten and curve up her nose. And Dr. Albert said, I didn't do it. And in the absence of evidence, the court had no choice but to grant summary judgment.
Is this argument that you're making right now the we don't know which doctor did it argument, or are you saying that? Okay.
No, Dr. Albert. I don't know that it's...
Because that doesn't strike me as a winner, so I would like you to focus
Oh,
on
no,
that.
no,
Okay.
of course not. No, I don't think the parties dispute that Dr. Albert's the one that did the revision rhinoplasty.
Okay.
Although the pleadings were framed in the context of counter-defendants.
Somebody did it, yeah.
Somebody did it, but I don't know who. But in the absence of any evidence that Dr. Albert, who performed the surgery, directly went against her wishes, Judge Brain had no choice but to grant summary judgment. I see that I'm out of time. Unless the court has any more questions, I'll sit down.
Thank you, Mr.
Thank you, Your
Keller.
Honors.
Thank you, Your Honors, for indulging us this morning in this argument. I hope that Mr. Kelly and I can bring to bear a little bit more to help the court render its decision. On the issue of damages, I think the panel has asked a number of questions suggesting what would Ms. Petta have the order of the court be? And the answer to that, as suggested by Judge Johnson, was possibly to have Judge Brain enter an order remitting the verdict to some other figure, some other dollar amount specified or supported by the evidence, which places the issue squarely back in the trial judge's discretion, which the court would then have already said had been abused. That's why I think the older remedy of a remitter, where the verdict is remitted down to another dollar figure, or in the case of an additor, increased, and then that amount is then offered to the defendant or the plaintiff, in the case of an additor, as the possible judgment. That practice seems to have disappeared simply because trial judges have so much discretion on this issue that they don't exercise their right of remitter or additor very often. I think the more appropriate remedy is to send the case back to be retried, and even if this court agrees with the plaintiffs that there was adequate evidence on liability, the damages just don't add up. There was no expert, accountant, CPA, there were no financial statements offered, and to the court's question on what was the $1 million, the answer was the collectibles, and that's found in Judge Brain's minute entry from summary judgment motions. It's record on appeal number 317. On the issue of Ms. Petta's counterclaim for medical battery, the Duncan case tells us that for the consent to be effective, it must be to the particular conduct or substantially the same conduct. To state that Ms. Petta gave blanket permission to operate on her nose goes too far, because her testimony by affidavit on the summary judgment record was that I specifically said more than once, I do not want the tip of my nose altered. Our research disclosed a Florida case that is exactly factually on point on this issue, where the Florida Court of Appeals said in the Moretsky case, without the patient's consent or contrary to the patient's express instructions is what constitutes actionable battery.
Has the, excuse me for interrupting, but has the bankruptcy court abandoned this claim to Ms. Petta?
I think the order that we attached to our reply brief was Judge Haynes' ruling saying that the interest Ms. Petta has as a debtor in the claims in this action are not property of the estate. So it's not a question of the trustee owned it and then it was abandoned by the estate, but Judge Haynes' order says it never was property of the estate.
I thought the order, I'm a little confused on this, I'm sure, but I thought the order referenced the denial of selling the claim. And I was a little confused by the selling the claim reference.
Correct. Under the bankruptcy code, the trustee has the, I am out of time. I don't know if I may have extra time.
I think the presiding judge will let you finish if you do it quickly.
The trustee has not only the right but the duty to sell assets for the benefit of creditors. The 363 sale, which I think was the motion that was pending at the time, the procedure, the auction that was to take place, did not take place because the court held that Ms. Petta's rights in this state court litigation were not property of the estate. So I think as a question of bankruptcy procedure, this was never determined to be, under Section 541, to be property of the bankruptcy estate or trustee. Just one final point. All right, I want to circle back to the First Amendment. The defenses or the burden of proof placed on the plaintiff all stem from the First Amendment, and that's an important determination. If consumers are subject to liability for things they say about those who operate on them, for those they deal with in purchasing goods and services, it will have a chilling effect on that right. And that's something this court should decline to do.
Thank you, Mr. Lawrence. We appreciate the arguments of counsel here this morning. We're going to take this matter under advisement. We'll issue our written decision in due course. We're going to take a brief recess to allow counsel in the next case to come forward and get prepared for the next argument. Thank you.